Oh, good. What did that cover? People and multiple?
Crap and heritage. So they work in Saudi Arabia, Myanmar, and recently Afghanistan. And yeah, so it was established in Afghanistan, so it's gross sales. And they work with master experiencing kind of dying.
Oh, okay.
To support them and connect them to international.
Brian, as in.
Yes.
Yes, sorry, not using
No,
it
no.
now. Yeah. That's a good.
Dying quite a bit.
Probably would be, wouldn't it?
With
Textiles.
yeah, both textiles and then with the carpets is their biggest market. Yeah, out of Afghanistan. Yeah, it was great. Big change.
Well, this is much better.
You say that, but it's consistent.
Yeah, that's true. But I mean, well, I think you know, I don't hesitate to ask.
Yeah.
Thank you. No, I don't really
as
appreciate
well,
it.
but I might not actually redo
Yeah,
it
it's
because
just today.
And then you find out that someone's leaving. And you're right.
I know, yeah. And I imagine it's even more formal in the High Court where there's so many more courts. A limited group here, but still.
Yeah, absolutely. And then, of course, it goes to the as well.
Yes.
And, I don't know who's the judge, is I'm sure. Say, your chat, did you not come with me?
No,
He likes to do that thing.
He's here.
Oh, is he? I'll keep in mind actually, in case the chair gets stuck. Right.
Okay.
All right.
Mr. Sullivan.
Lady, thank you. I was just about to come to the three cases referred to in paragraph 53 of Lord Reed's judgment in Marix. First is the decision of Mr. Justice Burse in the Peak Hotels case, which is behind tab 12 of the authorities bundle. The facts are set out in paragraphs 1 to 17, but if I may summarise, this was a dispute concerning control of a hotel group run through a company called Peak Hotels and Resorts Group Limited, and that was a joint venture company between a number of individuals. That company owned another company, ARGL, which in turn owned a third company called Silverlink, and Silverlink owned the various hotel companies. A company named Pontwelly loaned $168 million to ARGL, which was secured on its shares in Silverlink. ARGL defaulted and Pontwelly took the shares, which were then transferred by Pontwelly to one of the parties to the joint venture. And other parties to the joint venture then brought a claim against that party that the whole enterprise formed part of a dishonest conspiracy against them. And one of the remedies claimed was an injunction requiring the transfer of the shares in Silverlink back to ARGL. And that's the relevant remedy for the purposes of Lord Reed's analysis. And you can see that in paragraph 65 of the judgment. Damages were also sought, but they're not material. And it was argued that the claim was barred by the rule against reflective loss. Mr. Justice Burse agreed that the damages claim was barred by the rule against reflective loss, just that's paragraphs 58 to 60, but not the claim for an injunction. His analysis is at paragraphs 69 to 73, and the court will see from the very beginning of paragraph 69 that he was focused on the problem of double recovery. And I won't go through all of the paragraphs, but that then feeds into his conclusion at paragraph 73. In the final sentence, there's no problem with double recovery, and so no problem of the kind considered in Johnson and Gore with creditors. Coulson refused to strike out the injunction claim. The next case is Marrow.
So that could be categorised as falling simply because that aspect of Johnson and Gore Wood has fallen.
It could, my lord, I accept that.
I mean, it could.
It could, I accept that. Tab 13 is the Marrow decision of Mr. Justice Tier. This was an application to discharge a freezing order on the ground that there was no good arguable case. And the reason it was said there was no good arguable case was because of the rule in against reflective loss. The claim was about two joint venture companies named OOV and HMC, each of which had 3 shareholders. So again, they were joint venture companies. Each of those companies owned a VLCC, which is a very large crude carrier. And pursuant to a shareholders agreement, those VLCCs were given to a company, Sea Pioneer, which in turn entered into a contract of affreightment with another company, PDVSA. Sea Pioneer assigned its rights back up to the OOV and HMC companies, and a dispute arose in connection with that contract of affreightment. One of the shareholders, so one of the joint venture parties, arranged for that dispute to be compromised. And the complaint in this case was that they had compromised that claim too low. One of the shareholders obtained a freezing order against the other shareholder and against Sea Pioneer. And its claim was that the value of its shareholding in OOV and HMC had been diminished by reason of the undersettlement of the contract of affreightment claim. And it claimed damages, but it also claimed specific performance of the shareholders' agreement. And it said that Marrow had specifically to perform that agreement by making payments back to the JV companies, HMC and OOV, to make up for the undersettlement of the claims. Now, Mr. Justice Tier held that that remedy, the last remedy that I mentioned, was not, or arguably not, covered by the rule against reflective loss for the purposes of the good arguable case test. And his analysis can be found at paragraph 22. I just invite the court to read paragraph 22. Mr. Justice Tier's analysis wasn't limited to the principle against double recovery. He identified each of the principles that Lord Reid identified in Barrett's, just rule in prudential. He identified the principle of company autonomy, and he identified the avoidance of prejudice to creditors. But nonetheless, he reached the decision that the remedy sought in this case did not fall within the scope of the rule.
Can I just ask you a point about creditors, which is a point of some interest in the present case? It might be said that denying recovery on, call it the prudential ground or the Foss and Harbour ground in the present case, would prejudice the interests of creditors of SSPLC, because if a claim for specific performance were to be granted, then the assets of the company would be pro tanto increased, and creditors would stand to benefit. Likewise, if it's denied, the creditors are pro tanto prejudiced.
Again, my lord, I accept that as a matter of the facts of this case, that's possible. But the answer to that is that the company should bring its claim if it wants to. The liquidators should bring the claim if they wish to bring the claim. Now, of course, it's part of the background to this case that the claimants in this case tried to obtain an assignment of the company's claims from the liquidator, but it hasn't happened. We don't know why, but it hasn't happened. The liquidator has been invited to assign the claims, and it's chosen not to. That's its right. That's their right, rather, and that forms an important part of the basis for the rule, the company autonomy point. And as Lord Reid points out in Marex, there will be circumstances where creditors would be prejudiced if the shareholder was allowed to have their claim. Now, and that's possible here, my lord, because although my learned friend says, well, if this claim went to trial, it would be possible for the court to order damages in lieu of specific performance paid to the company. And that might be possible, but it isn't the only way that the claim is put. In fact, the principal way that the claim seems to be put when one reads the particulars of claim is an invitation for the court to order damages to be paid to these shareholders, not to the company. Now,
Well, I think that's fair comment, but I detected that Mr. McCall-Fritz was somewhat backtracking that way.
well, my lord, but the rules...
It's not an idle question, because in principle, one decision that's open to this court is to say that the claim for specific performance alone can proceed, even though a pure damages claim cannot, and likewise possibly a claim for damages in lieu cannot.
Yes, my lord, that must be right. But again, we come back to the principle of company autonomy. And for the reasons that Lord Reid identifies in Marex, if the shareholder is allowed to bring its claim, then that offends against the principle of company autonomy, because it's not their decision.
Well, I understand that point, and I think you're right to emphasise it. But even so, it's a bit odd on the facts of this case, because we're protecting the autonomy of a company that only comes into existence after the relevant contractual obligation.
Well, that's right, my lord, but a company that was always envisaged to be created, and its creation is a necessary prerequisite to the loss, to what's gone wrong in the first place. What's gone wrong in this case, and I know I've already made this point, is a failure to transfer assets to that company. If the company didn't exist, then we don't even get to that point in the story. And although it's right as a matter of fact to say the company didn't exist, in my submission, it doesn't make any difference to any of the causes of action. Wouldn't make any difference to a claim for breach of director's duties, which we'll come to. It wouldn't make any difference to a claim under the 1999 Act, which, of course, expressly provides that it applies even if the company isn't in existence at the time of the contract under Section 1.3. Now, the final case referred to by Lord Reid in paragraph 53 is GZ Kun, which is a Cayman Islands Court of Appeal decision behind tab 14 of the bundle. Now, this was an application for Kia Timmet relief to prevent an alleged breach of fiduciary duties said to be owed both to the company and to the shareholder. The allegation in this case was that the shareholders in a company named Dorsey Ventures, which was the sole limited partner in an investment fund, had, in breach of duty, caused that fund to make a capital call against Dorsey. And so the injunction sought was an injunction to prevent that capital call being paid. The decision of the Court of Appeals given by Sir Bernard Ricks, and you can see at paragraphs 52 and 53, there is reference to an analysis of peak hotels and Marrow. At paragraph 55, there's reference to Marex in the Court of Appeal, but of course we didn't have the Supreme Court judgment by this time. And then the conclusion at paragraph 68, and it's back down to paragraph 71, which I won't invite the court to read now, but the conclusion is that the remedy sought in that claim, Sir Bernard Ricks held, did not fall within the scope of the rule in prudential. Returning.
What do you say about his comment in paragraph 71 about present case being one where the loss has not yet occurred and the injunction is not used to recruit, but to prevent loss. And so that he says, in any event, both these cases, those cases and this one, reflect a need to see the company maintained whole.
Well, my lord, again, well, I suppose 2 points. First, that analyses loss in a way which, in my submission, isn't the key factor. Maybe, in fact, I maybe have one point expressed in different ways, but the second way is again the company autonomy point, which is whether or not we're looking here to prevent loss or to recoup loss which has already happened. The decision is the decision of the organs that have been given that decision under the company's article. And so that, in my submission, is why, after he has analysed those cases in paragraph 53 of his judgment, we see what Lord Reed says about them in paragraph 54. Which I accept comes back perhaps to a point that the Lord Justice Arnold made for the short adjournment, that the focus here is on Foss and Harbour. Those cases demonstrate how that Court of Appeal was prudential in considering that the rule established in that case based on the absence of separate and distinct loss was necessary in order to avoid the circumvention of the rule of Foss and Harbour. The exception to that rule is a derivative action. So drawing those points together, in my submission, Lord Reed is clear in paragraph 35 and in paragraph 52 that the nature of the remedy doesn't impact on the application of the rule. The rule applies not just to claims for damages but also to claims for other remedies. And it is clear in my submission from the analysis between paragraphs 52 and 54 that where one's dealing with a claim for specific performance, we're still dealing with the rule against reflective loss, and an attempt to structure a claim so it's simply to claim a remedy of specific performance.
But as I think your submissions have just demonstrated, this has got nothing to do with loss, because as we've just seen, the principle applies even where we're preventing loss ever being occurred in the first place. So it is all about company autonomy. It is all about who is the proper claimant, loss and harbour. It's got nothing to do with damage or loss at all, has it?
Well, my Lord, my primary submission is that on the facts of this case, it wouldn't matter either way, because when one analyses the facts of the present case, we clearly are talking about a loss. But in the abstract, your Lordship may very well be right that if it is said that as is the case, that loss is a constituent element of the prudential rule, as Lord Reed explains in 52 to 54, the claim would be barred by Foss and Harbottle anyway. Subject to any questions the court has, that was what I was going to say about background of appeal. And then I'll turn now to the 1999 Act ground of appeal. And the short point here, which I'll seek to develop, is that Section 4 of the 1999 Act does not have the effect of disapplying the rule in prudential. There's no challenge in this appeal accepts to the judge's finding that SSPLC has a cause of action under the 1999 Act. So the question is not whether it has a cause of action, but it's whether BIG has a cause of action as well.
Well, I'm puzzled by that way of putting it. How can there be any dispute? It has a cause of action. It had a pre-existing cause of action before the company ever came into existence to enforce the contract. Sorry, cause of action.
Cause of action
is not the right way of looking at it. An existing contractual right.
The question is whether it can bring the claim. I accept. I shouldn't have used the phrase cause of action. It's whether it can bring.
I was wrong as well.
And the question is whether, as a result of the company obtaining a right of action as a result of Section 1, the right of the promisee, being BIG or whoever, is affected by that because the right under Section 1 is obtained by a company.
Quite so, my lady, and then that begs the question, well, what is meant by effect in Section 4 of the Act? I've showed the court paragraphs 34 to 37 of the judgment of Lord Reed in Direct, which are material to this question, but I won't go back to them. The court was shown by my learned friend, paragraph 10 of Lord Reed's judgment. I think I can take this quickly because my learned friend and I are on the same page here. In paragraph 10, about 6 lines down, that aspect of the rule is understandable on the basis of the reasoning of prudential, since its rationale is that where it applies, the shareholder does not suffer a loss which is recognised in law as having an existence distinct from the company's loss. And that's a point that Lord Reed comes back to in paragraph 39, which again my learned friend showed the court, where the rule applies, the problem for a shareholder is that the shareholder doesn't suffer damage which is separate and distinct from the damage suffered by the company. And because it doesn't suffer damage that's separate and distinct, the law doesn't recognise that shareholder as having sustained any recoverable loss. Whether or not the company decides to pursue its course of action. And as the court has seen, the reasons for that rule are principally company autonomy and the potential conflict if a shareholder is allowed to bring his claim, which Lord Reed identifies in paragraph 37 of his judgment. So that's partly the settlement problem, that if the shareholder has its own claim, then the directors may be prejudiced or prevented from settling a claim, which in truth is a claim which should be brought if it's brought by anyone, by the company. And as I pointed out in my skeleton argument, there are a number of pragmatic advantages to the rule, which Lord Reed identifies in paragraph 38. And so, again, drawing those points together, where a court is faced with a claim, a contractual claim, by a shareholder for a loss which is purely reflective of a loss caused to the company, the contractual right in question is the conferral of a benefit on the company, and where the 1999 Act is not excluded by the contracting parties, then in my submission, one is left with a situation in which the law, on the face of it, does not recognise the shareholder's loss as being recoverable as a matter of law. And that's, in my submission, a straightforward application of Marek's. But as my ladyship identified, the question on this appeal is really, does Section 4 of the 1999 Act transform that loss into a loss which the law does recognise as being separate, distinct and recoverable?
Well, again, you emphasise loss, but what about the contractual right as distinct from the loss?
Well, in the first instance, in my submission, one is dealing with loss for the reasons that I've, on the facts of the present case, the reasons that I've identified. So in my submission, there is no separate question about a contractual right. But if we were dealing with a case where there was no loss, and so I suppose an altruistic shareholder wished to enforce the terms of a contract even though it was of no financial benefit to them, directly or indirectly, then in that situation, I accept that the principles to be applied would be different. And one wouldn't be, in that situation, dealing with prudential at all. One would be dealing with Voss and Harbottle without prudential. But one would still be left with the same dilemma, because, well, or, sorry, not quite the same dilemma, a similar dilemma. Because then one would be asking, does Section 4 disapply the rule in Voss and Harbottle? But on either basis, if I could start with the prudential basis. If Section 4 does have that effect, then to use Lord Reed's language at paragraph 37, that would mean that Section 4 has the effect of subverting the rule in prudential. And even if we're just in a Voss and Harbottle situation, it would have the effect of subverting the rule in Voss and Harbottle. And it would give rise to all of the problems that the rule in prudential, as explained in Marex, is supposed to prevent. The impact on company autonomy, conflicts, problems in settlement. Now, I accept, of course, that Parliament could, if it wanted to, do that. It could say, we don't want the rule in Foss and Harbottle or the rule in Prudential to apply in claims like this. But in my submission, that way of construing Section 4 requires it to do too much heavy lifting. In my submission, it isn't what Section 4 was intended to do, and it isn't what it does. Section 4 does what the explanatory of the Act says it does. We can see that behind tab 2 of the Authorities Bundle at page 12.
Just to give you fair warning, Mr. Sullivan, as somebody who chaired the Civil Procedure Rules Committee for nearly 4 years, the explanatory notes were the one thing that was always wrong. And I'm sure the time will come when one is dead accurate, but I'm afraid my experience has been poor.
Well, Lord, I hear what your Lordship says, so perhaps I'll skirt very quickly over this point.
Anyway, which paragraph?
It's paragraph 21, which deals with Section 4. And as the judge,
So Mr. McCall, for instance, that supports him.
he does, my lord, and I don't accept that for the same reasons that the judge below didn't accept that. And it's, as the judge below said, it's reflective of what the Law Commission said in its report that led to the Act. What Section 4 in my submission is seeking to do is to make it clear that the right of the shareholder to bring it, or well, the right of the contracting party to bring its claim isn't affected directly by the existence of the third party's cause of action. So what effect means in Section 4 of the Act, in my submission, is that the Act itself does not remove the contracting party, the primary contracting party's cause of action. But that cause of action still remains subject to the rules of law. And so, for example, if in the present case the shareholder had suffered some separate or distinct loss that didn't fall within the scope of the rule in Prudential, then Section 1 wouldn't have any effect of preventing him from recovering that loss. And in my submission, the broader construction of effect advanced by my learned friend, which is, I think, simply have any impact at all on the contracting party's cause of action, simply can't be right. And an example can illustrate that.
But just before you give us your example, we just have a look at the present case, bearing in mind the way it's put in the explanatory notes. Perhaps the right conferred by Section 1 in addition. So, first of all, we have the world in which the 1999 Act doesn't exist. And therefore, SSPLC has no cause of action in contract. And in those circumstances, BIG can enforce its contractual promise, and you accept that. Yes?
Well, unless SSPLC has a different cause of action.
That's leaving aside any different cause of action, for sure. Yes. I appreciate you've got your argument to apply this duty to cover. But ignoring that for the moment. So, at that point, BIG as the promisee has a right to enforce the contract terms in your favour. So along comes Section 1, and hey presto, by virtue of parliamentary intervention abolishing privity of contracts to that extent, the company now acquires a cause of action. And what Section 4 says, according to the explanatory note, is that this new right from Section 4 is additional to what the promisee had before. So how can it have the result that the promisee loses the right that it had before?
Well, its right remains subject to rules of law, Lord. And in my submission, that's doesn't prove repetition. The purpose of Section 4 is to do no more than that. It's to say that the Act itself doesn't remove a cause of action, but the court's still left with the position, well, has the shareholder suffered a recoverable loss? And we know what Lord Reed says about that in Prudential. If the company has a cause of action, then the shareholder hasn't suffered a recoverable loss. So, as I say, the only way of squaring that circle would be either to accept my argument or to say that Section 4 removes the rule in Prudential where the cause of action of the company derives from the 1999 Act. And in my submission, and the rule in Foss and Harbottle, if that's what Parliament had intended, in my submission, clearer language would be needed.
Well, I take your point that it certainly doesn't say that the rule of Foss and Harbottle doesn't apply. And I also take your point that at the end of the day, we are concerned, if you look at it in Foss and Harbottle terms, with company autonomy. That's the key point that you're making, and I see that. But I think one of the points that Mr. McCall-Fritz touched upon was to say this was an inroad into the principle of privity of contract. It was deliberately a small and confined inroad into privity of contract, and Parliament, having resisted doing this for so many decades, when it finally came around to doing it, didn't simply abolish privity of contract, it created a very small, narrow exception to it. And he says we should approach these statutory provisions through that prism. What do you say to that?
Well, I think an answer to that is that when Parliament drafted this Act, it allowed contracting parties to contract out of it if they chose to do so. And this responds to a couple of points that Malone and Fred made. So Malone and Fred said, when the parties agreed their contract, and this responds to a couple of points that Malone and Fred made. So Malone and Fred said, when the parties agreed their contract, they specifically decided that the company wouldn't have a right under the contract. Well, I don't accept that as a matter of evidence. I don't accept that there was any evidence that there was a specific decision to that effect. But if there had been one way of doing that, the most obvious way perhaps of doing that would be to exclude the application of the Act. And that's also an answer to Malone and Fred's floodgates argument. Because if you allow this in, it'll hugely expand the scope of the rule. But the court may know that in most commercial contracts, the 1999 Act is excluded. So in terms of the effect of any decision on commerce, practically speaking, one would think that it would be fairly minimal. But to return to my Lord's question, that in my submission is the answer here. That there isn't a huge impact on privity of contract and the party's freedom to contract because they can contract out of this Act if they choose to do so. But perhaps if I can come to the example that I was going to give. If one imagines a claim by a company and a shareholder So the shareholder's claim is for diminution in the value of their shareholding of £100, because the company has lost £100. And they both go all the way to trial. The company's claim is under the 1999 Act. It's not a party to any contract. At trial, if the court decides to order a payment of £100 to the company, the rule against double recovery will mean that there can't be any payment to the shareholder. That would be the 1999 Act, Section 1, affecting the claim of the shareholder. Because if the company didn't have its claim, then the court would have ordered £100 to be paid to the shareholder. Now, it must be the case in my submission that one couldn't have double recovery in that situation. It can't be right that the defendant who has caused loss of £100 could be ordered to pay £200 in damages. But if my learned friend,
I think the Supreme Court told us that double recovery was not the rationale for
this is nothing. This is an example that it just happens to be about double recovery, but this is an example that's coincidentally about double recovery. What I'm saying, my lord, or seeking to say, is it can't be right that the word affect means has any impact at all, because if it did mean that, then you would have double recovery in the examples I gave. But as I say, in my submission, although the shareholder still has a cause of action, it's subject to the rules of law, including the rule against double recovery, but also including the rule in prudential and the rule in Foss and Harbottle. That then brings me, subject to any questions the court has, onto the director's duty point. Which is the respondent's notice point. And of course, before I turn to the substance, if I was right about this point, then it would also dispose of the 1999 Act point, because Section 1 wouldn't then be having the effect of depriving any claim. The point here in my submission is fairly clear cut. The claimant's pleaded case, as I've said, is that Mr. Smith contracted to transfer assets to SSPLC, but then he didn't. If that's right, then it would have been in the best interests of SSPLC for him to transfer those assets, and it would have been in his best interests to keep them.
Well, is that right? Because he was under a pre-existing contractual obligation personally to transfer them. How can it be in anybody's best interest to break the law?
Well,
surely we should assume that they comply with the law.
Well, my lord, if I take that point, but then that is often the case when one is considering the question of a conflict of interest, maybe even invariably the case, because the very fact that the person in question has chosen to do something in their own interests rather than in the interests of the principal.
But the question is whether there's a conflict of duty. And why is there a conflict of duty if both his personal duty and his duty as a director of the company point in the same direction, namely to transfer the assets?
Well, because in my submission, there is inherent uncertainty in litigation, or perhaps I can put it this way, a bird in the hand is worth two in the bush. So if you have a director who has assets, but also has a contractual obligation to deal with those assets by transferring them to the company, in my submission, it's right to say that the assets in his hand are probably worth more than facing the shows in action. But even if I'm wrong about that, in my submission, or perhaps it's the same point, it would clearly be in the best interests of the company for the assets to be transferred to it. And so, in my submission, on the facts that are pleaded by these claimants, he would be in breach of his duty under section 172 of the Companies Act, and probably under section 175 too. Now, the judge below held that it was too early to tell, and my learned friend objects to the point and objects to reliance on my client's defence because it was filed after the decision of the judge below. But I don't accept that. In my submission, this depends simply on an analysis of the facts that are pleaded in the re-amended particulars of claim.
Yes, so you don't need the defence.
No, I don't need the defence. The court, in my submission, simply has to analyse those facts and ascertain, on the basis of those facts, whether it would or would not give rise to the cause of action. Just as it did, in fact, in connection with the 1999 Act. And if, having done that, the court considers that the company does have a cause of action for breach of director's duty, then there's no point in letting this matter go to trial, because the court knows what the answer is. It might be different if I was turning up to court today and making the point for the first time and it wasn't fair on my learned friend to respond to it. But that's not the position here. This is a point that's been live for a long time.
It's very artificial, though, isn't it? I mean, your client ends up trying to invent reasons why he might be hypothetically liable for hypothetical claims in order to defeat the real claim. Lord Reed was quite keen to cut down on all of that.
Well, my lord, that is the case in every single time a party applies for summary judgment on the ground of reflective loss. The party is always saying there would be a claim against me on the facts pleaded by the claimant.
Well, I understand pre-Marex why that would be right. But post-Marex, isn't it? That shouldn't be the case. People shouldn't be saying every time, well, look, I could be liable for this, that, and the other, and therefore claim falls because of the rule in Prudential. Is that not a fair...
Well, my lord, in my submission, that is simply the operation of the rule. If we got to trial and the judge found that SSPLC had a cause of action in respect of this loss, then the claim will fail. Subject to my lord's point about a pure specific performance claim, which for the reasons that I've sought to identify is not this case. But even then, we would then have Foss and Harbottom. That's all I propose to say about directors' duties. And so that then brings me to the final point, which is the cross appeal. Mr. Burgess and VIIL's only interest in this claim, in my submission, is through their indirect shareholdings in SSPLC. Their loss is the diminution in the value of their shareholdings one step higher up the chain in each instance. And in each instance, their loss depends upon showing a loss to SSPLC. And so to start with Mr. Burgess, in holding his shares in VIIL, he entrusted the decisions as to what VIIL should do to protect its assets to VIIL's board and ultimately the general meeting. And VIIL's only relevant asset for the purposes of this case is, or are, its shares in BIG. And VIIL only suffers loss by reason of a diminution in the value of BIG's shares, which in turn is caused by diminution in the value of BIG shares in SSPLC. So there is no separate and distinct loss in this case at any stage from the loss caused to SSPLC. And the rationales in my submission for the rule in prudential which were identified in Marek apply to Mr. Burgess and VIIL's claims just as they apply to BIG's claim. So, first, SSPLC is the proper claimant for these losses. It is the company that the injury has been done to. It is the company that has suffered the relevant loss, the recognised loss. Secondly, company autonomy requires that SSPLC should be allowed to decide whether to claim, whether to settle any claim, or indeed whether to assign any claim. If shareholders in corporate shareholders were allowed to avoid the rule in prudential, that company autonomy would be damaged. Thirdly, the bargain that the shareholder enters into of entrusting decisions as to the company's assets to that company's decision-making organ exists at each stage of the shareholding chain. And at each stage, the alternative remedies identified by Lord Reed are available. Voting in a general meeting, bringing a derivative claim, bringing a Section 994 petition. And then fourthly, the interests of creditors could be undermined if indirect shareholders are permitted to bring claims, just as they might be undermined if direct shareholders were permitted to bring claims, because money that should, if the claim is sound, go to the company which has suffered the real loss, may end up instead going to shareholders. And so in my submission, if the rule doesn't apply in this situation, it would create an unprincipled distinction between corporate and natural shareholders, which would undermine the rule in prudential and which would undermine the rule in Foss and Harbottle. And of course, on the facts of our case, there's a cause of action at each stage. So actually, if we supposed that there was no further chain, so the losses had in fact been suffered by VIIL rather than higher up the chain at SSPLC. In that situation, Mr. Burgess wouldn't have a claim. He would be the shareholder. The loss would have been suffered by VIIL. His only loss is diminution in the value of his shareholding or a loss of dividend. So he'd be barred. Why should he have a claim simply because there's another entity further along. Why should he be in a better position because the loss is suffered in a stage higher up, or rather 2 stages higher up than he is? Or perhaps the more pertinent question is, why should SSPLC be in a worse position than VIIL would have been? And those are my submissions on the cross appeal. If I might briefly turn my back, subject to any questions that the court has. Thank you.
Thank you, Mr. Sullivan. A reply, Mr.
My lady, yes. I will certainly not propose to be until 4 o'clock in reply, just some very brief submissions in reply, subject to any questions that my lady or my lords might have for me. My Lord Justice Arnold, in an exchange with my learned friend, speculated as to whether this case and possibly the rule in Prudential has nothing to do with loss and everything to do with company autonomy. My primary submission is, despite my sympathies with that way of analysing the rule, it's not open to this court, given Lord Reed's lead judgment in Marex. I'm not going to go over the old ground, but for the reasons that I explained in detail, Lord Reed was unequivocal that the rule is about not recognising share value loss and distribution loss. That is the entire effect of the rule. And so to say, well, it's really about company autonomy, in my respectful submission, is not open to this court. But if it is...
But then how does one explain what he says in paragraph 53?
Well, my lord, I was going to come to paragraph 53 in due course, if I might, but we can go there now, of course. Company autonomy is part of the rationale for the rule, but the fundamental underpinning of the rule is the principle in Voss and Harbottle. It's just when one properly understands the principle in Voss and Harbottle, it mandates the rule, but only in respect of share value loss and distribution loss. And that, again, I don't propose to repeat things I said before the short adjournment, but that's why it's so important to focus on what a shareholder is entrusting to the decision-making organs of the company. What actually is a company's autonomy relevantly about? And that's why I was at pains to emphasise that BIG did not contract in its capacity as a shareholder. It contracted just in its personal capacity.
Well, to be sure, but this is, of course, not necessarily a point against you, because if one says that this principle is all about these 2 specific types of losses, then it might be said to be a short step to the conclusion that if the remedy is one that is not about recovering those losses, but rather is about preventing loss or making the company whole, then in that sense, rather than in the recoupment sense, then why should the rule apply?
My lord, yes, I wholeheartedly agree. And I was about to say, if you were against me on my primary, right. I felt bound to make the primary submission. I didn't want to jump on a bandwagon not knowing what tune was being played. I felt it important to say to my lord that actually, as I read Lord Reed's judgment in Marex, the focus has to be on loss. But if I'm wrong about that and the focus is on company autonomy, absolutely it wins the case for me, or this appeal for me, not the case. But it wins the appeal for me because there's no aspect of BIG being permitted to enforce its primary contractual rights that offends against the principle of company autonomy. So if it's company autonomy, and my Lord Justice Arnold might well feel able to go as far as saying, well, the underlying principle is that company autonomy must be protected, and that principle is not offended. So that's a reason why either contracts are a case apart or claims for specific performance at the very least are a case apart. And if you go that far, then of course I win the appeal. But as my Lord Justice Arnold said about George Fisher before the short adjournment, absolutely, I just say George Fisher remains good law, irrespective of the 1999 Act. There's no issue about company autonomy because it's a right vested in the promisee that it remains entitled to enforce, irrespective of whether it happens to be a shareholder in a company that benefits from the contract at the time when it brings its claim. BIG, my lord, could transfer its shares to a third party before my lady and my lords give judgment. It'd still be entitled to seek specific performance of the contract. It just wouldn't have a claim in damages anymore, or its claim in might not be entitled to pursue its claim in damages. Its claim of specific performance would be inviolate, as it always must be. So, my lord, those are my two submissions on company autonomy. My learned friend said that Section 4 is disapplying the principle in Foss and Harbottle. It is doing no such thing. It is purely and simply designed to prevent the conferring of a right on a third party by Section 1 from affecting the right of a promisee. In all circumstances, and without exception, the conferring of a right on a third party cannot affect the primary right of the promisee. That is what Parliament provided. That is what, to the extent that the explanatory notes assist my Lord Justice Coulson, the explanatory notes say. And I said, and I maintain the submission, that actually the learned deputy judge erred in relying on erred in law in relying on the Law Commission report. But I say that if I'm wrong about that, and it is permissible to refer to it, then I am assisted by the Law Commission report. And just to make that good, if I might ask my lady and my lords to turn to tab 4 of the authorities bundle. At page 161, and just invite my lady and my lords to read paragraphs 11.1 to 11.4.
So, sorry, say again,
11.1 to 11.4, my lord, on page 161.
Yeah.
Would I be right in guessing that nowhere in this document is there any reference to either Prudential or Foss and Harbottle?
You would, my lord. And my lord, this is another bandwagon point. I say it's just not permissible, but if it is permissible, it helps me. And I'm bound to say it's not permissible because of how I understand the authorities, in particular Pepper and Hart, but if it is permissible, it positively helps. If the court had in mind, if Parliament had in mind the principle in Foss and Harbottle, along with all the many other principles of common law, then the fact of it having that principle in mind, again, positively helps me. Because Parliament provided in Section 4 that in no circumstances will the conferring of a right by Section 1 affect the right of a promisee. It is artificial and wrong to say, as my learned friend does, that if the rule in Prudential were engaged by SSPLC's claim under Section 1, it would not be Section 1 that was affecting BIG's right under the contract. True it is that the rule in Prudential would be the proximate cause of BIG's right being not just affected, but completely negated, nullified. But the anterior cause would be Section 1, because the rule in Prudential couldn't possibly be engaged unless SSPLC acquired a right under Section 1. So it's sophistry to say, oh, well, the rule in prudential breaks the chain of causation, so don't worry about Section 4. It would be Section 1 and Section 1 alone that would lead to BIG being unable to enforce its primary right as promisee, and Parliament said that that could never happen. Just on the hypothetical fiduciary duty point, I said, as I was slightly rushing, for which I apologise, to finish my submissions almost on time, that Lord Reid had mentioned that deciding whether the rule in prudential applied might call for the exercise of judgment. Just for my lady and my lord's note, that's at paragraph 48. It might actually be useful just to glance at it. I apologise, I don't know whether you have it to hand. But yes, at page 706 of the Authorities Bundle at tab 17. So it's after Lord Reid has quoted an important passage of Lord Bingham's judgment in Johnson. At the end of that paragraph is the sentence beginning. The second sentence reflects the fact that deciding whether a loss falls within the scope of the rule may call for the exercise of judgment. So Lord Bingham said, on the other hand, the court must be astute to ensure that the party who has in fact suffered loss is not arbitrarily denied fair compensation. And that is a respect in which the interests of creditors might come into play. So perhaps when I answered my Lord Justice Arnold's question, I was too hasty. Well, I would say I was being too focused on the issues in this appeal. I say that the fact that the company is now in liquidation is irrelevant to my submissions about specific performance of the 1999 Act, but could become highly relevant to whether the court decides to grant specific performance or damages in lieu. And so that's if it's available to the court, because it's not barred by the rule in prudential. Absolutely, at the pleading stage, then it might be a factor that comes into the equation. And it might be a factor also that comes into the equation in the exercise of judgment that Lord Reid contemplates.
I'm sure I'm being very dense here, but I'm not following the point you're making. You seem to be envisaging that even if you're successful on this appeal, there will be room for argument at trial as to the scope or the relief having regard to the rule in prudential or the rule in Foss and Harbour, depending on which way you look at it. I don't quite see how that works.
My Lord, no, only...
This is a once and for all decision, isn't it?
It's a once and for all decision, except for as regards the hypothetical fiduciary duty claim. And I'm bound to say that because the learned deputy judge said that was a matter for the trial judge.
That's why this reference to an exercise of judgment is a point against you.
No, my Lord, with respect, I say it's a point in my favour because it's a further reason why the learned deputy judge was right, alternatively within the wide ambit of his discretion, to say leave it for the trial judge. Because that exercise of judgment is appropriately an exercise for the trial judge on facts as found and as the circumstances as found. Of course, if the court decides that the hypothetical fiduciary duty claim bars any aspect of BIG's or Mr. Burgess's claim, that would be a once and for all decision. But as regards the hypothetical fiduciary duty claim, there are two other possibilities. You might say it will never engage the rule so as to bar the claims in this particular case. That is the ruling that I would urge my lady and my lords to make on the basis that a hypothetical fiduciary duty claim can never bar a claim for specific performance. And as regards BIG's claim in damages, for the reasons that I explained about how the fiduciary duty claim depends really on analysis on the conferring on SSPLC of a right by Section 1 of the Act.
Yeah, and if you're right on that, then the answer is never.
Exactly. And the third possibility, my lord, is that you might say it might. That is something that this court might say. And that's what the learned deputy judge said. So if you decide to leave undisturbed what the learned deputy judge said only about the hypothetical fiduciary duty claim, then there would be nothing that I could say to my learned friend come trial about him being stopped from trying to invoke the rule. That is all I'm saying. So perhaps I'm being overly careful in considering all possible outcomes. But in any event, I only rely on that as a further support for the learned deputy judge's exercise of discretion. But I say I don't actually need any further support for that. So paragraphs 52 and 53, which my Lord Justice Arnold touched on some moments ago. My primary submission is that there is no tension at all between the ratio in Marex, as explained by Lord Reid in the lead judgment, and paragraphs 52 and 53. And that is because, as my Lord Justice Coulson observed, the disapproval of Peak Hotels, Latin American Investments, and G was the result of and was targeted at the premise of those decisions being wrong. The premise of those decisions was in whole or in part that the rule in Prudential was about avoiding double recovery, and that was wrong. And so that's why Lord Reid disapproved them. But if there is a tension between the ratio, and I say in referring to the ratio, I come back to the point that I was at pains to emphasise this morning, that the real ratio is claims in respect of share value loss or distribution loss engage the rule in Prudential if the company has a claim in respect of loss of which those types of loss are reflective. That's the ratio. If that's the ratio, then any tension between that ratio and these two paragraphs has to be resolved in favour of the ratio. The ratio has to be afforded primacy. But I say, actually, on a proper analysis, there's no tension. And my Lord Justice Arnold's observations about those decisions were absolutely apt. They are to be properly understood as having been disapproved by Lord Reid for the reasons that I've explained. And as I said before, as regards Latin American investments, in my submission, Mr. Justice Tier reached the right result, but for the wrong reason. He ought to have said that the claim for specific performance was well arguable because it did not depend in any way on establishing any loss, let alone share value loss or distribution loss. If he had said that, then there would have been no reason for Lord Reid to disapprove the decision. And indeed, possibly, to pick up on my Lord Justice Arnold's point, if Mr. Justice Tier had spoken exclusively about company autonomy and then spoken about specific performance, there'd have been no basis for disapproving that decision either. My learned friend, before the short adjournment, sought to focus on what he called the purpose of the claim. And he said that the purpose of the claim was really to get loss that was compensation for loss that was a bit like reflective loss. And so the rule in Prudential was engaged. Whether the rule in Prudential is engaged has nothing to do with the supposed purpose of the claim. The only inquiry is whether the claim depends on establishing share value loss or distribution loss in a way that is impermissible. To say it looks a bit like a reflective loss claim, so the rule in Prudential is engaged, is exactly the kind of woolly reasoning that led to the unprincipled expansion of the rule in Prudential that Lord Reid deprecated. And that expansion grew and grew based on what Lord Millett said in Johnson until Lord Reid cut it right back. Lord Reid's surgical focus was on whether the claim depended on share value loss or distribution loss. So too, my learned friend's suggestion that the court should focus on substance depends on a very loose and imprecise analysis of the substance of this claim. the result of my learned friend's substance argument, if it were accepted, would be that the contractual promisees would be left with a contract that could not be enforced in circumstances where they contracted, they alone, before the company even existed. To ask whether the claims of the company and the shareholder both address the same thing that's gone wrong, in the words of my learned friend, is to fall into a category error. As I said before the short adjournment, there is a distinction between the equitable response to a contractual right, that being the grant of specific performance or damages in lieu of specific performance, and the equitable response to a threatened actionable wrong, which would require proof of loss in order to support it. So my learned friend just glosses over the fundamental distinction between a claim for specific performance or damages in lieu that has nothing to do with loss and claims that do depend on loss. And that is the problem too with his reliance on paragraph 35. And if I might just ask my lady and my lords to turn to that. It's at the tail end of that, well, that paragraph before the quote from Prudential. And my learned friend sought to place great weight on Lord Reed saying, sorry, just wait for my Lord Justice Arnold. Sorry, paragraph 35. Sorry, my Lord Justice, Lord Justice Coulson. I was just waiting for Lord Justice Arnold. But yes, absolutely, it's the weight that he sought to place on secure other relief. Now, it's damages or other relief. Of course, other relief that's distinct from damages includes, for example, equitable compensation. One can quite see that equitable compensation could engage, a claim for equitable compensation could engage the rule in Prudential if it were equitable compensation to compensate the shareholder for share value loss or distribution loss. And one can conceive of claims for other remedies that might engage the rule in Prudential. But they would only engage the rule in Prudential if they depended on establishing one of the impermissible types of loss. And because specific performance does not so depend, it does not engage the rule. My Lord Justice Arnold contemplated the possibility of allowing the specific performance claims to survive, but shorn of the claims for damages in lieu. And in my respectful submission, it would be dangerous and wrong in principle to take that course because it would enable the defendants effectively to frustrate the claim by transferring away the shares. You transfer away the shares and then say specific performance is impossible. And yet again, the contractual promisees would be left with no way of enforcing their primary contractual rights. So damages in lieu of specific performance are a crucial safeguard on the rights of a contractual promisee. And damages in lieu do not depend on, a claim for damages in lieu does not depend on the kind of impermissible loss that the rule in Prudential refuses to recognise. On the 1999 Act.
So I'm not sure I follow that. Suppose the shares are transferred away. Well, it's not then the claim for the value of the shares that have been transferred away.
The claim is for, so damages in lieu of specific performance are awarded on a conceptually distinct basis from damages for breach of contract.
To be sure.
So what the court would ask is, what loss has the company suffered by reason of the failure of the promisors to be able to perform the specific performance which I, the court, have ordered? And in making that inquiry, nowhere into the calculus comes the question of whether you need to show loss by BIG. And that point is made good by what I said before the short adjournment, was if BIG were no longer a shareholder indeed had sold the shares on the instant that it acquired them, transferred the shares at the instant it acquired them, so had no possible claim for share value loss, no possible claim for distribution loss, its claim for specific performance or damages in lieu would still be a good claim. So its claim for damages in lieu no more depends on it establishing loss that is recognised in law than does its claim for specific performance. So that's the reason why, in principle, the rule in Prudential can bar neither the claim for damages in lieu nor the claim for specific performance. It could only bar the claim for true contractual damages, but it can't bar the claim for true contractual damages because of Section 4 of the 1999 Act. Now, my learned friend said, again in response to, I believe, one of my Lord Justice Arnold's questions, that what I said about the purpose behind Section 4 and Section 7 wasn't right because Parliament had already sought to minimise the disruptive effect of the disruption of privity by allowing parties to contract out of the 1999 Act. The ability of parties to contract out of the 1999 Act is but one of the protections that Parliament provided for that was designed to ensure that the 1999 Act had the minimal possible impact on the rights of promisees or the rights of any third parties. The rights of any third parties I mentioned because of Section 7. So on a proper analysis, the fact that the court enabled the parties to contract out of the 1999 Act is completely consistent with, it's of a piece with, what I said the scheme of the Act was, which is to give to third parties the right that judges had been crying out for decades, and the Law Commission had first said was appropriate in 1937, but with minimal interference and preserving freedom of contract. So the ability to contract out preserves freedom of contract. Section 4 and Section 7 preserve the rights of, respectively, the promisee and any third parties who have rights or remedies in respect of the contract. My learned friend said the word affect in Section 4 cannot mean any effect whatever. But at the very least, affect must encompass a complete negation or nullification of the promisee's right to enforce the contract. As regards double recovery, which was an example that my learned friend gave to try to trim down the meaning, the natural meaning of Section 4, if SSPLC had brought a successful claim for damages under Section 1 of the Act, then BIG could not bring a claim for damages to compensate it for loss that was reflective of the loss that SSPLC had suffered. But that would be because of the rule against double recovery, not because of the rule in Prudential. So it would not involve Section 1 affecting BIG's right to enforce the contract. The thing that would have affected BIG's right to enforce the contract was that it would not have suffered any recoverable loss. And the reason it would have suffered no recoverable loss would have been that the company had recovered. Similarly, if SSPLC had brought a successful claim for specific performance, BIG could not bring a claim for specific performance. But that would be because the contract had been performed. Of course, if BIG had a claim for damages other than damages to compensate it for loss that was reflective of loss for which SSPLC had already been compensated, that claim would offend neither the principle that one should avoid double recovery, because SSPLC would not have recovered in respect of it, nor against the rule in Prudential. So the double recovery argument does not assist my learned friend. As regards the hypothetical fiduciary duty claim, my Lord Justice Coulson was, in my respectful submission, absolutely right. If this court struck out any part of BIG's or Mr. Burgess's claim by reference to the hypothetical fiduciary duty claim, it would be encouraging defendants to construct hypothetical possible claims and then try to engage the rule in prudential. And that is obviously undesirable. But in any event, my lady, my lords, you have my fundamental points on the hypothetical fiduciary duty claim ground if you are prepared to entertain it. And they are that specific performance is not available as a remedy. And any claim that the company might have against Mr. Smith only arises because of the conferring on the company of a right to enforce the contract under Section 1. So we're back to a parasite that kills its host. My lady, my lords, unless I can assist you further, those were my submissions in reply.
Thank you very much indeed. No further questions from the court. And so thank you very much to both of you for a very interesting set of arguments on a very difficult question. So therefore it won't surprise you that we will reserve our judgments and in the usual way, which you're no doubt very well aware of, when the time comes, drafts will be circulated and we'd be grateful for any comments by way of errors in spelling, not re-arguing, and if you can resist criticising our grammar, we'd be grateful as well. As you will also know, as usual, consequential matters, we hope you will be able to agree. If you can't agree, you'll have to make submissions in writing. There will be no attendance at the hand down, and it's an open question whether it will be a COVID hand down or a non-COVID hand down like this morning. But nevertheless, one way or another, there will be no attendance. So thank you very much indeed for all your help on these difficult matters.
Well done, Jacob.